SJC-11513, Commonwealth versus Nelson Melo.
Morning, Ms.
Good
Kempthorne.
morning. May it please the court, I'm Jean Kempthorne. I'm representing the defendant, Nelson Melo. In closing argument, the prosecutor told the jury, I'm quoting, "I've saved the best for last." That's Mr. Melo's statement. The videotaped statement to the police, which is Exhibit 53 in this case, was the jewel in the crown of the prosecution's case. It should have been suppressed in its entirety, and the failure to do so was important to the conviction. The tape was inadmissible for 4 separate reasons. First, it was the product of an illegal arrest. Melo had, the second is that Melo had invoked the right to counsel at the outset of the police station interview. Whether you look at that as equivocal or unequivocal, he did so at the outset. And
but
the police
it was
on.
It was post Miranda, right?
It was post Miranda, but not post waiver, in my view, Your Honor.
Okay.
The Commonwealth failed to sustain, this is the third ground, its heavy burden to prove waiver, given Melo's very obvious fatigue and his drug intoxication or withdrawal. Comes down to this: Melo was never given the option not to answer questions. He was screamed at, berated, commanded to answer, and his invocations of the right to counsel were repeatedly ignored.
Can I step back a little bit? The judge excluded most of this?
Not most of this.
Okay.
Most of it was allowed in.
Did the judge say it was involuntary at some point?
Yes.
Yes.
And that was how far in?
Page 155.
Out of how many pages?
Sorry. That's a fact. I don't have it at my
No,
fingertips,
that's okay.
but I will have it in a moment. It's 199 pages.
Okay.
So most of it was allowed in.
I thought the judge concluded, number one, that it became involuntary at some point, and that point was when the screaming started, or the vigorous cross-examination.
No, not when it started, but when it's sort of a confluence of things. Mm-hmm. There was, at that point, he was so clearly exhausted that he was banging his head on the table. He had fallen asleep for 26 minutes. He was being berated really from 1 hour in, the judge finds, the screaming starts. He had also repeatedly invoked the right to counsel. So it's really at the point where he...
Is page 155 after, because there were a number of times he talks about counsel. I'm just wondering, was it after the first of the exchanges about, no, I want a lawyer, no, I want a lawyer? Was it after that or before that? Page 155.
It is, no, the judge does cut it off once there's a clear invocation.
And that was after 155, but she cut off more on the involuntary. That's how I read her decision, and I may be wrong.
Go to 155, and at 155, there is no, as I'm looking at it quickly, there is no invocation at that point, but he's very tired.
That's how I read it. That she did 2 separate analyses. One was assertion of the right to counsel, and that occurred at some point, I think after 155, at least she finds that it occurred at that point. And then she does the voluntariness analysis and actually concludes that it became involuntary even before that.
So I want to just, as the fourth thing is, of course, the telephone, but then I'll come back to if I may, I want to start over with the first ground, which was the fruit of the illegal arrest. I say this case is governed by Brown versus Illinois.
This was not an argument made below.
This is not, well, the argument they made below was that he was effectively arrested at Morton Hospital. So once the judge had ruled that, in other words, the argument below Judge Cordy was that there had been an arrest even earlier.
An arrest or a custodial interrogation?
Well, really, since it's in custody, formal custody, then it is an arrest. There really aren't two rules. A formal arrest under Burkham versus McCarty is when Miranda kicks in.
No. If you're in the middle, if you come down to the police station,
right,
all right, and you voluntarily come down to the police station, at some point during the interview, it can turn custodial just because of the nature of the discussion. Does that mean you're under arrest at that point?
I believe it does. I think Burkham versus McCarty says
how can it possibly mean that?
Well, because it's really the same exact
so as soon as
objective standard.
As soon as it becomes in custodial, that means in the sort of from the perspective of the person that they're not free to leave, the police have to have probable cause to make it custodial?
Correct. Once you're past Terry, once the length of the detention...
As soon as you start aggressively asking questions and the court concludes that it becomes custodial, there has to be probable cause at
what
that
I'm
point?
saying, what I believe the law is, Justice Cordy, is that a reasonable period of detention for questioning is justifiable on reasonable suspicion. And that is Terry versus Ohio, and there's a certain amount of time. And then a continued detention. So in other words, yes, this custody in Terry, a reasonable detention, some detention for a short period of time is custody. There's also custody when someone is questioned because they're already, incarcerated. But in this circumstance, where the questioning goes beyond an initial Terry stop and ripens into, you can't leave, we're taking you into a cruiser, that is a formal arrest.
That's different. Saying, we're taking you down to the station, all right? That may well be the equivalent of an arrest. But are you talking in the middle of an interview? Somehow if it turns aggressive and the court rules, well, at that point it became custodial.
I would say, Your Honor,
the police had to have probable cause because it was an arrest?
Once you're past Terry, once you're past that short period of detention that is justified under Terry, now you have to go to PC.
But
there is no third layer.
But in this case, maybe you're not saying anything different. In this case, are you saying the arrest was effected when at Morton Hospital the police said, no, you're coming with us, we're going to continue this at the station?
That's what Judge Garsh said, and I think she's right. I was answering the question as to whether the issue had been preserved below. The argument below had been that it was actually earlier than that it had ripened into a custodial situation.
A custodial situation,
Hospital.
but not an arrest. The argument wasn't he was arrested, it was a bad arrest at the hospital, therefore everything else goes out. That was not the argument below,
well,
was it?
They didn't use, actually I can't tell you whether they used the word arrest, but they were saying that Miranda had applied earlier. And Miranda applies under Burkham versus McCarty at the time of a formal arrest, and that's is the person in fact detained or seized with the intention to form an arrest, to place the person under arrest. That intention, while it sounds subjective, is in fact objective,
but could I
then communicated to the person. Sorry.
Back up, but in this case, I'm just trying to say, are you saying Judge Garsh said, or determined that it was custodial, whatever, and maybe he was under arrest when he was taken to the police station? Are you saying it was before that?
That's not what I'm saying, Your Honor. What I'm saying is I'm living with Judge Garsh's determination. That's what I'm arguing, is that Judge Garsh correctly found that she made credibility findings and so forth, so this court should defer at least to those facts. She finds that Melo, at the time that he's put in that cruiser at Morton Hospital and transported, is in custody.
Right.
He is in custody then.
Okay, so but you're saying that's an illegal arrest?
Yes, because there was no PC. This is something Mr. Atwood just missed. There's no PC. The Commonwealth has conceded that repeatedly. They testified to
He
that.
did not
They
argue
conceded
this.
it.
So he did not argue this below. You said he just missed the point. The lawyer missed the point.
He missed the illegal arrest argument. Correct, Judge Justice
not
Cornyn.
only
He did not argue that the arrest was illegal. That's correct.
Not only did he not argue it, I've never heard it argued. Never. I've never heard of this argument in the context of Miranda. Is there any case law that addresses your claim that shortly after something becomes custodial, it's an arrest, and if there's not PC, regardless of whether Miranda has been given, it goes out? I've never seen the argument.
I think that's Brown versus Illinois.
But the U.S. Supreme Court would say almost certainly that Miranda would cure any taint, would it not?
No, Miranda does not cure the taint. It does not cure the taint. That's the holding. That Miranda is not an intervening event.
But Brown was, I haven't read it for a while, but that was a classic arrest. There was no question that Brown was...
No, it was exactly what happened here. It is a
they went to
placing
someone's
of...
home.
Just to remind you of the facts of Brown, it is you're coming down to the station for further interrogation. It's exactly this. It's this case. It is Brown versus Illinois. It's controlling. And what Brown says is, that's an arrest. That's an arrest. Miranda kicked in, and it doesn't go to the PC issue. I'm making that argument.
So here, Petitioner Richard Brown was climbing the last stairs leading to the entrance of his Chicago apartment when a police officer came, pointed a gun at him, and said, "Don't move, you're under arrest." Well, that's a little different than this case, I think.
I don't think it is important, Justice Cordy, that the fact of the arrest be communicated to the defendant. But Judge Garsh found that it was here. That is one of the three factors that I enumerated earlier, that both this court and the SJC...
He found that at the time that he was transported, that he left the hospital in the police custody, that they told him he was under arrest?
No, not at all, Your Honor. What I'm saying is that the fact that he couldn't leave, the fact that he was unable to leave was communicated to him. That's one of the three elements of an arrest. And I did not cite it, but your own, recent, no, let me strike that. So I think the cases are exactly as I'm saying. Judge Gantz, I really do not believe this is novel. The analysis is, was this past Terry? If it was past Terry, then you must have PC. And here there was no PC, and therefore the entire thing goes out. That is only one of four arguments, however. And I say, I'm living with Judge Garsh's finding on when the arrest takes place, when custody kicks in. I say there is no difference between formal arrest, a term used in Berkmer, and when Miranda is required. It is the same. And Berkmer is what tells you that. So Brown versus Illinois, I say, Judge Cordy, just so you're clear, there's no talismanic quality to you're under arrest for this analysis. It has to be communicated. The fact of the detention, that the person is not free to leave, must be communicated, but not in the words, you're under arrest. So that is that analysis. And now, if I may, you look very puzzled, and I want to answer any questions you have, Judge Gantz, but moving on to the second issue, which was the invocation of the right to counsel.
Well, the problem I see with it is that under your view, you can have a custodial interrogation even when the police did not wish to arrest the person.
Because it is determined, even though it's the second element of a formal arrest is with the intention to effect an arrest, it is determined actually objectively. And if they intended to detain the person, to hold them, to not permit them to leave, then that is an arrest. And this point...
But we've had cases in which the officers have said you're free, told them you're free to leave, and yet because of other reasons, we have said it was effectively custodial.
Well, that may, in fact, be the case, but that may have been that they didn't, in fact, truly intend to hold them. It's hard to say. Here, there's no question there was a true intent to hold them.
Do you have any, apart from Brown, which, as Justice Cordy points out, is a classic arrest, do you have any custodial interrogation case in which this argument has been accepted by any court?
I cannot answer that beyond. I mean, I'd be happy to send a letter. I can't off the top of my head. I have nothing that indicates to me there's any kind of third layer in between Terry and PC requirement. I'm aware of no law that supports that notion, that there's something else. There isn't. There's two categories. Once the police have stopped somebody, it's this or this. And I believe that's what all the Supreme Court cases in this area say. I'm happy to write a follow-up letter if that would assist the court. Okay. On the invocation of the right to counsel. Now, this is where I do part company with Judge Garsh. As I say, I'm happy with her analysis earlier, or at least I can live with it. On the invocation of the right to counsel, and this keys in a bit to where I think Mr. Atwood was not up to par in this case.
I would feel more comfortable if I had a lawyer. How does that differ from Morganti?
Well, because Morganti is pre-Santos, and Morganti is pre-Clark, and Morganti is pre-Hoyt. And so the law is different from Morganti. And what he's saying here is, and by the way, it did come out in evidence that he was told, we're just going to have you look at some pictures. So the police did admit that. So he says to them, I'm going to, and I think it's also interesting in looking at the whole gestalt of what goes on, he is told, sign. I mean, he is not given an option not to sign. And he is told that that form, which Judge Garsh found he did not read, he's told, and this is a quote, I'm going to need you to sign here that you understand those rights.
But that's a different argument. That's the argument that says there was no waiver.
That's right.
Not the argument that says there was a waiver, but he made an unequivocal assertion of right to counsel.
It's relevant to whether this is a pre-waiver invocation or a post-waiver invocation. I'm saying it's a pre-waiver invocation because there was no waiver at that point. At that point, he's just being told, acknowledge that I've told you your rights. And then he says, can I say something? Can I say something? Yep, says the detective. He says, I would feel more comfortable. That's not musing. I would feel more comfortable right now if I had a lawyer right now talking. Not, gee, maybe I'm going to need a lawyer. Maybe this is something that might involve a lawyer. No. I'd feel more comfortable right now talking with a lawyer. I say that's not even equivocal, but let's call it equivocal for the sake of argument. I think Judge Garsh finds it equivocal. She says it's not unequivocal. She seems to be saying it's equivocal. Now, Santos and Clark decided before this case goes to trial, not before this hearing, says the police now have only one option. They have to then say, hold the phone. Do you want a lawyer now? I don't really understand what you're saying. That's not what happens. And I believe this court must listen, not just rely on the transcript, because the transcript, as even the trial judge found, is not accurate, and it definitely does not convey the talking over, the barreling on. And he says, the detective says, I can find the exact quote. If you don't
go on from here.
If you don't want to talk, that's your right. But if you feel like you need a lawyer, I mean, the tone is, you're telling me you need a lawyer? Conveys the meaning, if you think you need a lawyer, then I can only conclude that you're more involved than you're saying you are.
He doesn't say that.
Pardon?
Well, I haven't heard the tone. Are you telling us that you are giving us what Detective Mulhern sounded like?
Yes, I am. I am telling you that the tone is, if you don't want to talk, that's your right. But, I mean, it's like almost everything before the but you can excise. If you feel like you need a lawyer, you know. And understand that he's talking at the same time. And Mulhern, and Melo responds, he doesn't know what to do. He wanted to help them, but it seems like, what do I say? I say this is clearly not compliant with Santos. It's not. Now, Santos is decided in August. This case is tried beginning on Halloween of 2012. They discuss Santos at the trial on another issue. This whole thing doesn't come up, and it's a major issue that should have been readdressed. I also want to point out that there are other fruits of this tape, the cell phone, the $1,600. There's lots of information. The only evidence of any use of guns, of an armed robbery, is Melo's statement. This is the key evidence in this case. And the jury, as for the strangler, I just want to say one thing. I know I have very little time, so I want to make a very important point.
But I'll make you one last point, but about 20 seconds.
I'm sorry, Judge. The Commonwealth goes on and on and on about how this is a strangulation case. That was that Melo strangled the victim. The jury rejected that argument. They rejected that argument. It's totally inconsistent with the way Melo behaved. They didn't buy it. This is purely a felony murder. And the verdict slip does not distinguish between the armed and the unarmed robbery issue. There was a mistake in the instruction. The judge did ultimately fix it on the second day of deliberations. The jury was out in this case over 2 days. Over 2 days. This was not a simple case. The letting in of Melo's statement, you cannot call it superfluous, redundant, cumulative. It is none of those things. There's evidence that came in pertinent to the felony murder that only came in through Melo's statement. So I urge the court, I'll rest on the brief with respect to what I say was an abuse of discretion, not to let counsel out when he moved and he said that he could not speak, could not communicate with the defendant. But for the 4 reasons I state, this case, the statement of the defendant should have been entirely excluded. And I do urge the court to read, to see the tape.
Thank you.
Thank you.
Good morning, Your Honors. May it please the court, Mary O'Neill for the Commonwealth. The one thing that comes across in the record of this case is a scrupulous adherence to the guidelines of this court and of the federal courts. Judge Justice Gantz, Judge Garsh was the motion to suppress judge, and Judge Kane was the trial judge. In the motion to suppress, this was a 4-day evidentiary hearing. You have before you the findings and the rulings that she made, and she did so very scrupulously.
She did, but let me get to this point. You haven't really addressed it in your brief so much, and maybe that's because it wasn't argued below. But this notion, I mean, the judge found that he was essentially in custody when they took him to the police station.
Correct.
And she rejected the testimony that he went voluntarily.
Correct.
So why isn't that an arrest under Kalp v. Texas?
It's not an arrest under, well, as Justice Gantz mentioned earlier, there is no case law that has developed the idea that somebody who is sent in a police car to be spoken to further as a witness
was not free to go.
He was not free to go.
He had to
That's
go
correct.
with them.
That's correct.
So how could they hold him?
Because he chose to go.
Well, she
didn't
sort of says he
choose to
doesn't
go.
choose to go. I mean, he didn't resist, but he was not told would you mind coming down the station and we can continue this interview there. He was told, take him to the station.
Right.
All right. So she finds that, and I'm just reading the language in Kaup, and it's just a little surprising to me. We have never sustained against Fourth Amendment challenge the involuntary removal of a suspect from his home to a police station and his detention there for investigative purposes, absent probable cause or judicial authorization. What does that mean? Here they went and got him in his house and brought him down for questioning, and even though he wasn't placed under arrest, technically the court says that's an arrest for Fourth Amendment purposes.
Well, for Fourth Amendment purposes, in terms of this particular case, Your Honors, it goes more to the investigatory piece. This was, how shall one put it? This was an ongoing conversation, and indeed, if the court is saying now that custody in a police car is equivalent to arrest.
Well, no,
then
it's
any
just that on
statements
the
made in
facts
that-
of this case, he has to go.
Right.
So if it is equivalent to an arrest, what follows from that?
Well, in terms of what was said in the police car, nothing. As the court found, there was no statements made that were suppressible. So once he arrived, am I missing something, Justice Bodford? I'm not
No, but the implications for what happened at the station. If it is an arrest, and I think you would agree there was no probable cause at that point.
Yep.
So then, if it's an illegal arrest, then isn't the product of the interview the fruit of an illegal arrest?
If that were the case, that should have been argued below. It was not argued below, and it's not preserved here.
But we
And
still
no-
have to look at it, right? Substantial likelihood of a miscarriage of justice, 33-year review.
Under a 33-year review, you can look at the court can look at anything it wishes, and I understand that. But the harm done here, if there was indeed an arrest, and the judge does not go so far as to characterize this as an arrest. She does not. She says he's in custody. I would adhere to Justice Garsh's determination that custody is not equivalent under these facts to arrest. She was very...
I wonder what she would have
Garsh
said if
never
somebody
had-
brought this case to her attention. Go ahead. I'm
Right,
sorry.
yeah, right. I mean, she never had the argument. There was never an opportunity for her to make this distinction. And also, I'm a bit perplexed, since it was a major part of the defendant's brief. How come you didn't address it in yours?
Your Honor, I think primarily because this particular case, we were following Justice Garsh's decision and keeping it to the four templates, the four time frames that she set forth. So, for instance, in this case, she set forth the first time frame in which he was in the family room. We addressed that. She determined that in the family room, he indeed was not under any custody. Then she made the second time determination of in the car, in the police car, and determined that while that was a custody, and again, as I said earlier, did not rise to the level of an arrest, he said nothing in the police car, so there was nothing to suppress
But
from
he
that.
said things when he was at the station. At the station, he said things.
Indeed, and at the yes, but again, just Judge Garsh only finds suppressible information post-waiver and considerably into the interview. And that's the key here with her scrupulous, I would say, investigation or looking at both the videotape and the...
Right, but the problem with Justice Cordy identifies is there's no doubt she was scrupulous.
Mm-hmm.
But this matter was not presented to her, and so this issue of she didn't, if it had been presented to her, she scrupulously would have addressed it, but she didn't. So what do we do?
I don't think comp controls here. I don't think comp reverses everything that it was said by this individual. I don't think comp is, I think comp is distinguishable in this case in that the facts of comp are different from the facts here, and this court has time and again found that this type of custody is not equivalent to an arrest that would lead to suppressible information.
Well, certainly Kaup on the facts is distinguishable since they went to his home at 3 a.m., got him out of bed, handcuffed him, and put him in the cruiser in his boxer shorts. So, yes, that is different than we have here. But the court doesn't seem to distinguish that. He was not placed under arrest formally. The court says, well, that's an involuntary removal to a police station for investigative purposes, and that's just like an arrest for Fourth Amendment purposes. So I'm just wondering, is it a factual distinction or?
Well, the factual distinction is an actual distinction here. You have an individual who is merely being a witness, nothing more. The reason that they go to Lecomte's house is to remove him. They have grounds
to question him.
Huh?
Well, they remove him to question him. Mm-hmm. They don't have probable cause. At least that's what the court says. There's no probable cause for his arrest, although it struck me there might be, but the court says no probable cause for his arrest. But he was detained for purposes of investigation, which is for a period of interrogation at the police station.
Isn't that what happened here? I mean, when the detective says we're going to the police station, that's what he's doing.
When he says he's going to the police station, he isn't saying he's arresting him.
No, that's the point.
Right. And he isn't, and Judge Garsh found that there was no intention to arrest him at that time. He was not even under suspicion at that time for the murder. Those were the findings she made of each of Dr. Bosco, Officer Schlageter, Officer Schwartz,
but the
Detective
point is they
Small.
took him there for further questioning. He was in custody. He had to go. He didn't have the choice of saying, gee, I don't think I want to go with you. So I guess I'm just wondering, it may be a little less extreme, but isn't it on the same wavelength as Kalk in that sense?
It may, I would have to say that I would distinguish Comte here based on the fact that I do not believe a bright line has been created that once an individual is in a form of custody, they are not immediately under arrest. And thus anything they say from that point forward becomes fruit of the poisonous tree. And in this case, anything that was said after the individual was Miranda.
Right, and that's what Brown is all about. Brown says Miranda warnings are an important factor to be sure in determining whether the confession is obtained by exploitation of the legal arrest, but not the only factor to be considered. Right? Temporal proximity of the arrest and the confession is an important matter. So here, if there's an arrest, the temporal proximity is sort of right away.
There's no confession here.
Well, no, they're statements. I don't think it matters whether they're confession. They certainly were used as inculpatory in the case.
They were, and they were in many ways cumulative of statements made in the family room. I would disagree with my sister in terms of the gun in particular, which was discussed in the family room. Okay. So many of the comments, the statements made in the tape that were admitted, and many were not, were cumulative statements, and there's no error there. But
Counselor, let me give you a breather from the issue now under discussion.
Certainly, Your Honor.
I had intended to ask defense counsel about this. The argument about the lawyer, why was it that the judge insisted that the trial go forward when Mr. Atwood obviously was emotionally traumatized by what the defendant had said to him? They obviously did not want to work with each other. Had this case been continued 5 times, did the judge think that the defendant was trying to stall? There wasn't any reason that I could see. Why did that happen the way that it did?
The reading of the record supports that the judge was, at the very least, put out by the fact that this was on the eve of trial, actually during just as trial was
I understand that, but what was behind that? I mean, that happens all the time. And, you know, a judge in a case of this magnitude would kind of give some deference to a defendant's choice unless this had happened 3 or 4 times before. Is there any indication that that's the case here?
No, there's no indication that that's the case here. The indication is, and as we've already spoken about, it was a very last-minute thing. And I think in addition to that, you will see Judge Kane's comments throughout the record of Mr. Atwood's prominence as a defense counsel, his abilities, particularly in murder cases.
The defendant didn't want him.
But he didn't tell anybody till just as trial was starting. And that seemed suspect. And for that reason, it seemed like this was something to just delay justice. And as the court is aware, that isn't sufficient to allow for a motion to continue. And what the record does reflect is Attorney Atwood's vigorous representation of Mr. Melo. Indeed, you can see the motions he's filed, and again, I'll point out that 4-day evidentiary motion, the motions in limine, and even his actions throughout the trial were those of a highly skilled litigator. So there was no harm done to Mr. Melo by having a prominent and well-prepared defense counsel defend him. Further, I'll just touch upon it. There's some argument about whether or not one of the four reasons was the phone call piece, which I think clearly does not lie. One, it was not brought up earlier. Two, that the statute requires an arrest. Hampton, Dagley, Caputo, and all the other cases state precustodial interrogation is not equivalent to an arrest that would require informing him of his phone rights. So that does not lie in this case.
Let me ask you this. Do you know whether Detective Mulhern was disciplined at all for his behavior in this case?
I don't know.
Any discussion of that?
None.
I mean, it was outrageous. Wouldn't you agree?
I'm sorry, Justice Buffett, I didn't hear your question.
I just asked whether Detective Mulhern was disciplined
okay.
for his conduct.
In the sense that he kept yelling at Mr. Melo, I suppose.
Yelling and trampling over his saying, no, I want to stop, I want a lawyer?
Well, now, when he started, as Justice Gantz mentioned earlier, he was right. This case was right under Morganti. And Clark...
I'm not talking about then. I'm talking about later.
Later. Yes. Later in the heat of the moment, certainly. He was yelling and he was screaming and he was looking for an answer from somebody who had been very good at equivocating for quite some time. Yes, I suppose it would make sense to have a conversation with him, but I don't think I'm in any position to condemn the gentleman. It's not for me to say. If there are, well, first, if I might, before I wrap up, unless there are further questions from...
I'm still struggling. I don't recall a case, I'm sure we've had them, where we have a Fourth Amendment issue, we have a motion to suppress, an argument not made and therefore not addressed by the motion judge under 33E review for a miscarriage of justice. Is it a miscarriage of justice if the evidence is more than adequate to support a finding of guilt, but there may arguably be a Fourth Amendment violation? Is that a miscarriage of justice under our 33E jurisprudence, or
No, it is not.
Or not?
No. A constitutional violation is not something that occurs in a vacuum. It can occur, but there still has to be substantial risk... substantial likelihood of a miscarriage of justice here. Given the facts, given the evidence put forth in this case, there is nothing to show that there was such a thing. You have an individual, Mr. Melo, who was the architect of this death of Mr. Chad Fleming. He lured him to his, I'll call it a lair because it was formerly his home, and he spent the time there robbing, armed robbery, and I would suggest to the court, strangling and killing Mr. Melo. There was considerable evidence to that effect. As the court has seen in the record, there were numerous witnesses all talking about the ways in which Mr. Melo had set this plan in motion and those who heard the plan going forward, even hostile witnesses who had to admit that there was something very noisy, very dangerous going on in the upstairs second floor apartment. Now, if I may just backtrack for a second, there was some talk of Clark, Hoyt, and Santos. Clark does not apply here. Clark deals with pre-waiver, which is not the situation here. This is a post-waiver case, and thus Clark's application of the Tompkins standard, or rather Clark's statement that Article 12 requires more than the federal Tompkins standard is not applicable to our analysis here. Further, Santos was very clear on wanting a lawyer, saying, I'm not going on with this conversation, I want a lawyer. Well, that's very clear. That didn't happen until approximately page 155.
No, but that's not the point. Santos says if it's equivocal, the officer may ask a very simple question. And then I think that's what Ms. Kempfort is saying. Not that we're not. If it's equivocal, the conversation that followed thereafter does not conform to at least what Santos, that's her argument, may suggest.
Well, I would argue, Your Honor, that Santos, while indeed permits now questions post an objectively equivocal assertion of counsel, there was no equivocal assertion of counsel. And, the court found, Judge Garsh found that he did not claim counsel in the beginning, but he did at approximately page 155, and that was an unequivocal assertion for counsel. So Clark and Santos and nor Hoyt.
She put it in the negatives, two negatives. Melo did not unambiguously assert his right to counsel.
Right.
What I read that to be is he ambiguously asserted his right to counsel, which sort of equates to equivocal.
I would not have the same reading, Your Honor. I would state that she found that he asserted his right.
It was post taking your side.
Pre-Santos, right?
It was pre-Santos, post-waiver.
Correct.
But I'm just saying, if you look at it through Santos's eyes, what do you say?
All right, looking at this through Santos's eyes, what I would say is that the officer now has an additional right, once there's been, as you have stated, an equivocal assertion of counsel. He now has the additional right to go and ask further questions to clarify whether or not there was an equivocal assertion, an assertion of counsel. That's what it does. There is a conversation that continues with Detective Mulhern in which he wants to make certain that they're going to talk, or does he want counsel? And that's what happens there. So I don't think there is anything in this case that runs afoul of Santos, and clearly, well, not clearly, but Clark is distinguishable, and Hoyt was just a direct statement, and there is no direct statement until page approximately 155 in this case, where he does clearly assert counsel. And from that point forward, everything is suppressed.
But am I right that Judge Garsh actually suppressed things before that? Didn't she make two separate findings, involuntariness and... It doesn't matter, I suppose. But
well, if it matters to you, just as it matters to me. She did make findings on voluntarity, but I don't think she picked apart too much before that point. Judge Kane did take some things out, not all that important right. for these purposes, during the motions in limine. So there is no reason to assert 33E here. This was a jury verdict that was a strong jury verdict. They had, as my sister mentioned, 2 days, which is fine. They went through all of the evidence in this case. And as the court has pointed out, yes, if the court wants to make law now saying that the drive in the police car is now sufficient for...
It's now an arrest, you mean.
Okay. I'll rest on my brief. Thank you, Your Honor.
Thanks.